Good morning, this is your Kelso Report for Wednesday, September 19th, and I'm your host, Clark Kelso. Our cases today involve a whistleblower who relied upon already public information in blowing the whistle, and the constitutionality of a Montana state statute that prohibits political parties from endorsing judicial candidates in nonpartisan judicial races. First, we deal with a whistleblower. Both federal and state statutes provide for what are known as qui tam actions that may be filed by a whistleblower on behalf of the United States or state or local government to recover damages for false claims, among other things, against government. The incentive for bringing these actions is that the qui tam plaintiff gets to share in a certain amount of the recovery which is secured. At times, if the qui tam action of the false claim is large enough, that can be millions or tens of millions of dollars. Well, in Bates v. Mortgage Electronic Registration, the plaintiff sued in federal court under the California False Claims Act, alleging that a number of national banks had made false representations in naming MERS, the Mortgage Electronic Registration System, as a beneficiary in recorded mortgage documents in order to avoid paying recording fees to counties. The district court granted the defendant's motion to dismiss after it concluded that the public disclosure provision in the False Claims Act applied. Now, to prevent plaintiffs from using the act to engage essentially in profiteering, the act provides that no court shall have jurisdiction over a qui tam civil action when the action is based upon the public disclosure of the allegations of transactions raised in the action. In other words, if the transactions have already been publicly disclosed, you can't run into court after the public disclosure and claim to be a whistleblowing plaintiff. Well, in this case, the Ninth Circuit agreed with the district court. The whistle had already been blown, everyone was aware of the transactions, and the plaintiff was therefore not entitled to proceed under the False Claims Act and make a recovery of a portion of the proceeds. Next, we turn to the First Amendment. Our next case here deals with the application of the First Amendment to campaign speech in the context of state judicial elections. Since 1935, Montana has selected its judges through nonpartisan popular elections. To keep the races nonpartisan, Montana makes it a criminal offense for any political party to endorse, contribute to, or make an expenditure to support or oppose a judicial candidate. And individuals who facilitate such activities may also be held criminally liable. In Sanders County Republican Central Committee v. Bullock, a Ninth Circuit panel majority struck down these statutes under the First Amendment. Because the statutes are content-based limitations on core political speech by an organization, strict scrutiny applied under, of course, Citizens United. Montana argued it had a compelling interest in maintaining a fair and independent judiciary, but the majority concluded the statutes improperly assumed that preventing political parties from endorsing judicial candidates was a necessary prerequisite to maintaining a fair and independent judiciary. Montana produced no actual evidence supporting that conclusion, and given the fact that in some 38 other states they actually require party nominations of judges, the majority concluded the statutory restriction was not actually necessary, and therefore the state could not demonstrate it was furthering a compelling state interest. The dissent noted that the majority's opinion was the first to hold that even though a state has chosen a nonpartisan judicial selection process, political parties nevertheless have a First Amendment right to endorse candidates. As the dissent noted, this means the political parties can work to secure judges' commitments to the party's agendas in contravention of the nonpartisan goal the state has chosen for its selection process. Now, this is an important First Amendment case involving judicial elections, a first case of its particular kind, and I think we might see the Supreme Court take this case up, so the Supreme Court can reconsider some of its own precedents involving state judicial elections and free speech. The Supreme Court's decisions in this area, its most recent decision in White about 8 years ago, it may be time for reconsideration. The Supreme Court has been essentially pushing state judicial elections towards a more partisan model, and I think the court may wish to reconsider that direction. That's it for today's Kelso Report. Have a great day in the law.